Good afternoon, everyone, and welcome to our webinar today. My name is Elise Sweeney Anthony, and I'm the Executive Director of the Office of Policy at the Office of the National Coordinator for Health Information Technology. It is a pleasure to share with you today some more information on information blocking. As some of you may have joined us before, you'll be aware that this is our fourth webinar related to our recently released rule. That's the 21st Century Cures Act Interoperability, Information Blocking, and the ONC Health IT Certification Program's final rule. The rule was released, posted on our website. We include in there, if you go to healthit.gov/cures rule, you'll find information including a copy of the rule. You'll also find information regarding our previous webinars, including recordings and the PowerPoints. And we also have some fact sheets that hopefully are helpful for folks in identifying areas of interest within the rule. The next step in the process will be the rule being put on public display in the Federal Register. One of the things that we are doing as part of release of the rule is to share information with you via webinars, and this is one of that series. The first three focus on information blocking, an overview of information blocking, another one focused on conditions of certification, and a general overview as well of all the provisions in the rule. What we're doing now is we're starting the second part of our series, and that focuses on receiving questions from stakeholders via the webinar function. So if you look on your screen, you'll see a Q&A section, and that's where we would love for you to type in any questions you have, and then we'll be able to get to as many as we possibly can during this webinar. We're going to start with an overview presentation by Mike Lipinski, who's the Director of Regulatory Affairs here at ONC, as well as Mark Nee, who is a Senior Policy Advisor in the Office of Policy. So let's go to the next slide, and we'll take care of a couple of housekeeping provisions. First, we want to note that the materials in this presentation are based upon provisions in 45 CFR, parts 170 and 171. We also want to note that we make every effort to make sure that that what we note in these presentations are accurate and an accurate reinstatement of those provisions. But the presentation itself is not a legal document. So this is usually where I encourage folks to take some time and review the rule. What we focused on in the rule, in the final rule, is not only laying out the final policies and providing regulatory text as well, but also to look at responding to the many comments we received. And we want to take the time, again, to thank all of our stakeholders for responding and providing their comments and their insights into the rule. We received more than 2,000 comment submissions, and they've been very helpful for us as we were thinking about finalization of the rule. Excuse me. So with that said, you'll notice as you go through the rule that you'll see that there are comment and response sections where we specifically respond to the specific points that were raised by our stakeholders. So a wonderful way to go through the rule is to look at the preamble as well as the regulation text, and then also the complementary materials that we have on our website, such as fact sheets, et cetera. So before we dig further into information blocking, let me just give a heads up on upcoming webinars. We'll also have a webinar on the certification criteria and the conditions of certification on April 22nd at 3 p.m. There'll be one on application programming interfaces on May 6th at 3 p.m., a compliance timeline presentation on May 20th at 3 p.m., and also a presentation on health IT for pediatric care settings on June 3rd at 3 p.m. So we encourage folks to join those as well. They'll follow a similar format to what we've laid out today for the information blocking webinar today. And with that, let's go to the next slide. And I'm going to turn it over to Mike Lipinski to start walking through a high-level overview of some of the provisions in the rule before we move to question and answer. Mike?
Thanks, Elise. Good afternoon, everyone. And I think it's now at this time it's also on the our friends on the West Coast, so good afternoon to them. Although I guess if you're listening from Hawaii, first, lucky you, and two, good morning still to you. So let's just jump right in. I'm only going to spend like maybe not even 10 minutes here on the first part, describing some of the definitions and the overall framework of information blocking before I turn it over to my colleague Mark, who will talk to you a little about the exceptions and the complaint process, and then we're going to hopefully make sure we leave a lot of time for Q&A. So what you see on your screen now is the information blocking definition in reg text, and so that's in 171.103, and it follows what was outlined in the statute in terms of the definition of information blocking. But the key point there's a couple actually corrections we'll need to make here. It's really conducted by health information technology developer of certified health IT, and I'll talk about that in a second when we talk about the quote-unquote actors that are subject to information blocking. But also key point is really B there. So until 24 months after publication of the final rule, EHI is limited to the data elements represented in the US CDI standard. So that's what will need to be made available for access, exchange, or use to not be subject to an information blocking claim. Let's move to the next slide. So this is really breaking down the definition you just saw up on your screen, and this is kind of become my favorite slide, and hopefully yours too if you're covered by information blocking. So here are really the elements, right? So it's not just all about the exceptions. It's whether or not you're an actor, whether the information that's being requested for access, exchange, or use is EHI as we defined it. And also, just as importantly, the next two elements you see on your screen, which are, is it an interference what you're doing? And depending on who you are, whether you're a provider, which has a different knowledge standard, they have to know that what they were doing was an interference, or if you were a health information network or a developer of certified health IT, you should have known what your practice was likely to interfere with access, exchange, or use. So those are very key elements. And then, like I said, Mark will talk to you about the exceptions. And then within the definition itself, as you saw on the prior page, if the law says don't, federal, state, even, and we further explain what the law was, that it could be administrative decision and so forth, said not to share the information, then you wouldn't be an infra blocker. Let's move to the next slide. So just equally important, if you're found to be an information blocker, what type of penalties are you subject to? Those are prescribed in statute. So if, as you see on your screen here, you're a developer or HIN/HIE, you can be subject up to $1 million per violation, civil monetary penalties. But if you're a healthcare provider, you are subject to appropriate disincentives, and those disincentives need to be established through rulemaking conducted by HHS, which has not yet occurred. So stated another way, there are no quote-unquote penalties identified yet for healthcare providers. However, in our program, the certification program that ONC conducts and administers, there are penalties for developers of certified health IT if they are found to be an information blocker under the condition of certification that prevents or regulates information blocking. So that would be, they could be subject all the way to a certification ban, not allowing them to certify any products. And then that would be listed on our what's called affectionately the CHAPL, Certified Health IT Products List, if they were banned, and if any of their products were terminated in relation to information blocking. Let's move to the next slide. Compliance timelines, also just as important as the two other slides I just discussed with you. So the final rule set out a delayed compliance timeframe, and it's from the publication date of the final rule. And as Elise mentioned to you, our rule is on display on our website right now. Next steps are before publication are OFR puts it on display on OFR's website, and it sets a publication date. Then the rule is published in the Federal Register. It's that, if you guys are familiar, the tri-column version pages, and that's when the compliance timeline would start. And that's 6 months delay. And then the other piece that's in the rule is that related to this is enforcement of information blocking once compliance is required. And what you see on the screen here is there is a rulemaking that needs to be completed by OIG. First, the proposed rule has to be published and out for comment, and then a final rule about the civil monetary penalties, the approach that they will use, the process procedures. And they've also indicated, the department has indicated, I should say, that discretion would be exercised, as you see on your screen, that such conduct that occurs before that final rule, this is finale on there, so I apologize for that, will not be subject to information blocking penalties. So in between that potential time frame of when compliance starts and when that rule finalizes. Can we move to the next slide? All right, so I'm going to talk to you quickly about two of those elements that were on the screen earlier. They're going to be actors, as you can see on your screen now, and that's what we call the entities that are identified in the statute, subject to the information blocking provision. So there were 4 of them outlined in the statute, and we proposed healthcare providers. The definition was cross-referenced in the statute from the Public Health Service Act, which we adopted in the final rule. For developers of certified health IT, we were consistent with what we proposed. The key pieces are that it has to be a claim of information blocking while they were a developer of certified health IT, so they had to have at least one product still certified under the program when there was a claim for information blocking. And the other key piece is that they're subject for any information blocking claim, not just claims related to certified health IT. And then the other actors, as you see on the screen, health information networks, health information exchanges. In the final rule, we combined or gave one definition for both those. So that's one of the key pieces. The other parts are we limited the types of actions. So, for example, to be considered a HIN, we removed the substantially influences part of the proposal, which we thought was both, broad, commoners thought, which were broad and vague, and we agreed with that in removing it. We focused the scope on HIPAA-focused actions or exchange, so like treatment, payment, operations. We also revised the definition to be essentially 3 or more unaffiliated individuals. It reads in the actual definition as more than 2 unaffiliated that are able to exchange with each other. So those are like the key pieces, and we had, as mentioned earlier, an in-depth presentation on this, and that's now available on our website, including the slides and the recording of that presentation. And let's move to the next slide. So the other element that I want to talk to you and just reiterate today is the EHI definition. We had proposed a very broad definition, but as with the HIN and HIE definition, we were very cognizant of actors being subject to HIPAA rules as well, those actors that I went over with you in the previous slide. And so to address the concerns of those actors which were concerned about, for example, having to segregate EHI because it's a much broader definition than what was EPHI, we took that into account, and as you can see here, a much more focused definition we finalized at this time, and we think it should be very administratable by the actors in terms of that it's a widely understood in the by these actors who've been subject to the HIPAA rule, and they're already collecting this type of information or maintaining it or making it available for access, exchange, or use. And I think at this point, I am going to turn it over to my colleague, Mark, to give a quick overview of the exceptions and then the complaints process. Mark?
Yeah, great. Thanks, Mike. Yep, next slide, please. Hey, everyone. Happy to be here talking about the exceptions and the complaint process. Like Mike said, we have a very detailed presentation online, and I'll just go quickly through the exceptions and the complaint process, and then we'll get to the Q&A. So in the final rule, we finalized 8 exceptions that benefit actors by offering them certainty that when their practices with respect to access, exchange, or use of EHI meet the conditions of at least one exception, those practices will not be considered information blocking. For those familiar with the OIG's anti-kickback statute, safe harbors, the exceptions operate in a similar manner. We proposed 7 exceptions and we finalized 8. We added the content and manner exception. One important point that I want to highlight about the exceptions generally is that an actor's practice that does not meet the conditions of an exception would not automatically constitute information blocking. Instead, in those situations, the practice would need to be evaluated on a case-by-case basis to determine whether information blocking occurred. For instance, whether the practice would rise to the level of an interference or whether the actor acted with the requisite intent. So as you can see on the screen here, we've restructured the exceptions a bit from the proposed rule into two categories. So on the left-hand side of your screen are exceptions that involve not fulfilling requests to access, exchange, or use EHI, and those are finalized in section 171, 201 through 205. And on the right-hand side of your screen are exceptions that involve procedures for fulfilling requests to access, exchange, or use EHI, which are finalized in sections 171, 301 through 303. All right, so I'm going to jump into the exceptions now. So the first exception, number one, is the preventing harm exception. This exception is necessary because preventing harm to patients and others is a top priority of ours at ONC, and we believe it's a central theme as we advance interoperability and patient access to their records. This exception recognizes that the public interest in protecting patients and other persons against unreasonable risk of harm can justify practices that are likely to interfere with the access, exchange, or use of EHI. The second exception on the screen is the privacy exception. So this exception recognizes that there are many situations when protecting the privacy of EHI should override the need to share EHI. And the central theme here with this exception is that if an actor is permitted to provide access, exchange, or use of EHI under a privacy law, then the actor should provide that access, exchange, or use. But the actor should not be required to use or disclose EHI in a way that is prohibited under state or federal privacy laws, such as HIPAA. And throughout the rule, we emphasize our alignment with HIPAA as much as possible. The third exception is the security exception. So this exception is necessary because actors should not be deterred from implementing security measures or engaging in other activities that safeguard the confidentiality, integrity, and availability of EHI. We understand the significance and the overwhelming benefits of those types of practices. This exception is intended to cover all legitimate security practices by actors, but does not prescribe a maximum level of security or dictate a one-size-fits-all approach. The fourth exception on the left-hand side of your screen is the infeasibility exception. Sometimes there are legitimate practical challenges that prevent an actor from complying with requests for access, exchange, or use of EHI. We understand that these things happen, and this exception accounts for those types of situations. For instance, an actor may not have and may be unable to obtain the requisite technological capabilities or legal rights or other means necessary to enable access, exchange, or use of EHI, or cannot fulfill a request because of uncontrollable events or an inability to unambiguously segment the requested EHI, and this exception would cover those situations. The fifth exception is the health IT performance exception. So this exception recognizes that sometimes actors should be able to temporarily take down a system or degrade the health IT to improve the overall performance of the health IT. And that's okay under this exception, provided certain conditions are met. All right, so now I'm going to shift over to the right-hand side of the screen. So these are exceptions that if all the conditions are met, the actor would still need to provide access, exchange, or use of EHI, but with the procedures we lay out. So the first exception is the content and manner exception, or put another way, it's the what and how exception. And I'll talk about what I mean there in a minute. We did not propose this exception, but it is related to our proposals regarding the definition of EHI and the reasonable alternative means for accessing, exchanging, or using EHI that was part of our proposed infeasibility exception. This new exception addresses two groups of comments comments about what actors must provide in response to a request for access, exchange, or use of EHI, and comments about how actors must respond to a requester in order to fulfill a request for access, exchange, or use of EHI. And I'm going to spend a little bit more time on this exception because it is really important. And I say that because it works as a funnel of sorts for other exceptions like the fees, licensing, and infeasibility exceptions. By working through the content and manner exception, you will be able to, or the regulated community will be able to gauge whether other exceptions should be considered. For instance, in most cases, the fees and licensing exceptions will only be used within the context of the content and manner exception because the conditions of those exceptions do not apply if the actor is fulfilling a request in any manner requested. All right, so now I'm going to talk about the content, which is the what. So up to 24 months after the publication of the final rule, an actor must respond to a request to access, exchange, or use EHI without a minimum the EHI identified by the data elements represented in the USTDI. And this 24-month period will provide actors with time to practice and prepare for the sharing of all EHI and sunset any non-compliant technologies. And it also creates a clear and actionable deadline for when all EHI must be available for access, exchange, or use. So then on and after 24 months after the publication date of the final rule, an actor must respond to a request for access, exchange, or use of EHI with the EHI defined in 171.102. As far as the manner goes, and that's the how, there are two parts, the manner, any manner requested, and the alternative manner. So an actor must fulfill a request in any manner requested unless the actor is technically unable to fulfill the request in the manner requested, or cannot reach agreeable terms with the requester to fulfill the request. If an actor fulfills a request in any manner requested, the actor is not required to comply with the fees or licensing exceptions. So the way this would work is that if a requester requests access, exchange, or use of EHI in a certain manner, the responding actor will have the opportunity to reach agreeable terms that are not limited by the fees or licensing exceptions, and the actor can negotiate agreements in whatever manner they choose based on the market rate. If the actor can't reach agreeable terms with the requester, then the actor would fulfill the request in an alternative manner. And so now I'm going to talk a bit about the alternative manner. So if an actor is technically unable, like I said, or cannot reach agreeable terms with the requester to fulfill the request, then the actor can fulfill the request in an alternative manner. If an actor responds in an alternative manner, they must fulfill the request without unnecessary delay in the order of priority that we lay out in the rule, and you can only move down to the next order of priority if technically unable. The first is certified technology, certification under our program, and this is given precedence because it advances a certified standards-based approach. Technically unable to provide the certified technology, then you would bump down to the standards-based technology, which is using content and transport standards specified by the requester and published by the federal government or a standards developing organization accredited by ANSI. And then last is the catch-all alternative machine-readable format, including the means to interpret the EHI agreed upon with the requester. One very important thing to note here is that in contrast to the requirements for responding in any manner requested, any fees charged for licenses granted by the actor related to fulfillment of a request to access, exchange, or use EHI in this alternative manner would need to satisfy the fees exception or licensing exception as applicable. All right, so that got us through the content and manner exception. The fees exception, number 7, our goal with this one is not really to set any particular fees related to products or services regarding the access, exchange, or use of EHI, but instead to allow the market to define the appropriate price for those products and services as long as certain methods are followed and certain criteria are met. It is also intended to address practices that constitute rent seeking and opportunistic fees and other exclusionary practices that we've heard about throughout the years. Actors who seek to satisfy this exception will not be prevented, and this is an important point, will not be prevented from making a reasonable profit in connection with the access exchange or use of EHI, as long as the applicable conditions are met. All right, and then the last exception here is the licensing exception, number 8. This exception recognizes that sometimes a license is necessary to get the EHI out to patients and others, and it allows actors to protect the value of their innovations that improve healthcare delivery and benefit patients, and charge a reasonable royalty in order to earn returns on their investments. Okay, next slide, please. All right, so here you have a bit about the complaint process. Clearly, based on this rule, you understand that deterring and addressing information blocking is really a top priority for ONC and HHS. We've been continuously receiving information blocking complaints over the years. And what we say in the rule is that we're going to implement and evolve the complaint process by building on existing mechanisms, including the process for providing feedback and expressing concerns about health IT that's currently available at the link that you see on the screen. And this page on our website is dedicated to reporting information blocking. If the information provided falls within the scope of information blocking within the rule, we'll share it with the appropriate HHS agencies, including the Office of the Inspector General. All right, next slide, please. Just real quickly, this is language from the Cures Act and provides certain protection from disclosure for information related to a claim or suggestion of possible information blocking. One point I do want to note here is that information blocking claims and information received by ONC in connection with a claim or suggestion of information blocking are protected from disclosure under the Freedom of Information Act. That's an important note there. Next slide, please. All right, before we move on to the Q&A portion of the session, I just want to emphasize once again that we have a ton of great information, like Mike and Elise said, on our website, like easy access to the rule, fact sheets, and previously recorded webinars. We also have a list of upcoming webinars that Elise mentioned, so please check it out. We think it'll be really helpful to you. Next slide, please. All right, and then last, this one's pretty clear. We just want to thank you once again, everyone who called in today, and also, of course, everyone who has submitted comments throughout the comment period to help us finalize this really important rule. And with that, I'll just open it up to the Q&A portion. Beth, you can take it from there.
Thank you, Mark. So I want to thank you all for noting the Q&A feature down at the bottom. It is very clear that you all have found it. We are getting a lot of questions in. I'm going to do my best to triage them and send them to our experts to answer. We're going to answer as many of them as we can live right now. So several of you are asking very similar things. So I'm going to try and collate a little bit as well. Mike and Mark will be handling these questions. Again, we will try and get through as many as we can. We have about a half an hour, and I have about 70 in the queue so far. So we'll get started right away. Again, this webinar is being recorded, and the recording and the slide deck will be available on ONC's website, which is healthit.gov/curesrule, after they have been made 508 compliant. So Mike, I want to start off with you and ask if I can have you talk through, we've gotten about, I see 8 different versions of this question so far, talking about the compliance date interaction with the OIG enforcement discretion and their timelines. So several questions that revolve around, it's unclear if an OIG enforcement delay also delays the compliance date, and how the 2 dates work together, and essentially how that would work, and what is the equivalent for a compliance date if there's a change in those effective dates.
Sure. Thanks, Beth. So let's start with compliance dates and effective dates, okay? Because they're different as well than just enforcement discretion. So our rule has both effective dates in it and compliance dates. And so the effective date is when certain provisions in the rule become effective. And so what does that matter? Well, it means like then I can bring my product in to get certified because it's now available for certification. So for example, our API criterion, it won't be effective. Those provisions that have the new the new e-prescribing standard in it, for example, won't be effective until 60 days after the rule publishes. The compliance dates, on the other hand, they run from the day the rule is published to a certain date that we've identified via the rule. So for example, when it comes to information blocking, it's 6 months from publication. So while those 2 months that run before other provisions are effective, those are 2 months into the compliance time frame. So I guess maybe I'll take a quick step back. As you know, and I think I said earlier, the rule is on display on our website right now, a version of the rule. It's got a footer on it, that disclaimer that talks about how the official version will be the one that publishes in the Federal Register, which has obviously not occurred. And as I said earlier, we're going back and forth with OFR. It will eventually display there, and when it displays, it sets a publication date. When that publication date finally happens, that's when all those other dates start to kick in, the timeframes for them, the compliance dates, the effective dates. Once compliance dates, you hit it. So once you get to those 6 months, you as an actor, if you're a provider, a developer, a HIN, must comply. You are subject. There's no must comply because you're just subject to the information blocking provisions if you meet the definition of actor. And so the enforcement piece, and you should think of this as one HHS, but we talk about it in the rule, and I've talked about it in my slide decks too, right? OIG, there's a statement in this rule signed by the Secretary Azar, and it says that it will not begin, enforcement will not begin any sooner than when those 6 months, the compliance starts, and it would be after the CPM final rule, civil monetary penalties final rule, is issued and publishes. And they also, and there's a key part in the preamble that I would point you to, it said, discretion will be exercised such that conduct that occurs before that time being when the final rule publishes, before that time would not be subject to information blocking civil monetary penalties. But it is different. So like there's a discretion piece there, right? So all that time, you could be subject to penalties. But what we've said in the rule is discretion will be exercised not to subject actors to penalties. So hopefully that part clears it up in terms of both publication and when those dates start to kick in, the timeframes for them, and then how compliance is different than enforcement. And to just drive it home a little more for you in terms of a distinction, there is an information blocking condition of certification for developers of certified health IT. It too is subject right now to a 6-month delayed compliance timeframe. But after that timeframe is up, ONC would be in the position to exercise discretion over any actions that took place that could be information blocking. So hopefully that clears that part up. Beth,
thanks.
Any further questions?
I do. I have a follow-up on that specifically that folks are asking about. Is ONC going to delay implementation and enforcement of any of this, of information blocking, due to COVID-19?
Yes, we've got a lot of, I think we've got a lot of those questions. You've probably even seen some press about that at this time as well, and you've been seeing other actions done by HHS. And I think, obviously our top priority, the department, is to protect the health and well-being of Americans. And, we, in light of COVID-19, we're definitely assessing, just as you've seen the actions being taken already, the interoperability rules and when they would be when, you know, any type of enforcement or compliance would be required, and to make sure that, you know, we are strengthening our response and success of everyone in terms of both the government and the healthcare community in combating COVID-19.
Thank you. I'm going to move on. We have a lot of questions, so everyone bear with me as I try to triage them in a way that hopefully answers as many as possible in a group. There are some questions that relate to the relationship between actors and certified health IT, and I think there's probably two pieces. We're going to have to get to the second one as well, that's talking about the relationship between EHI and USCDI and compliance timelines to USCDI, but let's start with the first question, talking about entities that are actors and whether they are considered an information blocker or are subject to information blocking provisions, whether or not they use certified health IT.
Yeah, thanks, Beth. I can take this one. So the answer is yes. Actors are required to meet the information blocking provision regardless of whether they use certified health IT. And when we talk about, you know, we're talking about actors, the healthcare provider, health IT developer, certified health IT, or health information network or exchange as we define in the rule. It is important to note, however, that in order for an individual or an entity to meet the definition of health IT developer of certified health IT, as Mike just mentioned, which is one of the actors, they must have had, at the time the practice in question that's subject to the information blocking claim, they must have had one or more health IT modules certified under our program. So there is that connection for health IT developers of certified health IT to the certification program. And just as background, kind of our thinking with this was that the Cures Act does not prescribe that only practices involving certified health IT would implicate the information blocking provision. And the way we read it is that the intent of the Cures Act was to limit the application of the information blocking provision to practices involving only certified health IT. It seems like the information blocking provision would have included language that tied enforcement of the section to the operation or performance of only health IT products certified under the program. So instead, the way, you know, it's looked at in the, you know, for information blocking purposes is that it's an interference with the access, exchange, or use of electronic health information as defined in our rule. And that's the relevant information, not the focus on certification. But it is important to note that certification, of course, comes into play for the conditions of certification, which is another part of the rule.
Thank you, Mark. So I'm going to take an opportunity to see if I can restate some of what you said that helps to address several of the questions that we're getting that are specifically about USCDI. And I think I probably need to talk more about the content and manner exception. So we'll get to that in a few minutes, but I'm going to just restate something. So when we say that our actors required to meet the information blocking provisions regardless of whether they utilize certified health IT, it should be noted that the USCDI portion of the content and manner exception is relating to that being a list of data rather than specifically you have to send as certified to the USCDI. So that I think hopefully will help clear that up because there's a lot of follow-up questions that are sort of misconstruing the USCDI and certification with that information blocking timeline because of the alignment of EHI to that at least list of data types for that short-term exception. Did I cover that pretty clearly? Get that right?
Yeah, that's right. And if you look at the language in the content and manner exception and also in the information blocking definition, it's like the data elements included within the USCDI, which is the key point there.
Thank you. I think that is the key point for several of these questions. Let's move on. I'm going to ask Mike, if you could, we're getting several questions that are asking very specific, is my organization, and we've got a payer, we've got a data registry for quality reporting, and several others here actually, asking if that organization is considered a HIN or an HIE. Can you talk a little bit about the functional definition and what that means for the HIN HIE portion of information blocking?
Sure. And I guess you know, I've gotten some of those questions directly as well. And we're not really in a position to, and we didn't do so in the rule because we got those questions and comments obviously on the rule as well, the proposed rule, to answer fact-based scenarios, questions about particular entities, because it's really about how that entity functions, whether or not they meet the HIN definition, right? So it's, you know, you may have multiple business lines, and depending on your business line, that one particular business line could be a HIN, you know, how it functions. It can meet the definition of a HIN, but the rest of what you do isn't. So it isn't just a clear-cut, I'm this, am I a HIN or not? No, it depends on what you're doing. Do you meet the definition? And so it's a functional definition, and again, we do not specifically exclude any particular entities, such as payers or, you know, carriers. And the other piece I think worth mentioning on that point is that we're looking at what, you know, what we'll be able to do in terms of issuing guidance going forward. As we said multiple times in the proposed rule and in the final rule, information blocking is going to be a case-by-case situation. We're trying to see, and I think I've mentioned this on one of my, at least on one or two of the presentations I've been involved in already on the rule, and it's actually stated more in our section of the I'll call it part one of the two parts of the rule, which is on ONC enforcement under the conditions, because that's where the comment came in. But we talk about Executive Order 13892, which is issued by the President last October, and it was regarding pre-enforcement rulings, and essentially equivalent to giving like advisory opinions, which for those of you who are familiar with OIG and the anti-kickback statute, they do in certain, you know, when they get requests in, and we're looking to see, you know, what we can do in that regard to be more specific. However, when it comes to the HIN and HIE definition, we're taking in all the requests or questions and trying to figure out how we can best answer in a more broad way those questions. So to see how many of them are similar to give you and how we can distribute that answer response to those. So we continue to give us those questions about HINs and HIEs, and we'll look to see how we can best answer that in a more broad way at this point, and then as we go along to see whether or not we can start to issue more like advisory type opinions. When I say we, I mean the department on that, in that regard. So that's the best I can give you on the HIN HIE piece right now. We're not going to answer, hey, I'm, you know, whatever registry, or I'm whatever plan, am I a HIN? Because it's really, you need to take a look at the definition and are you doing those things. We try to lay out pretty clearly in the preamble and the reg text, you know, what are the various, we'll call them elements or criteria, that factors that need to be met to make you a HIN, and including the piece about enabling unaffiliated entities to exchange. And we talked about what that enabling meant, which was not only the capability, but the discretion to exchange amongst themselves. So maybe I'll just try to say it again, like if you are, you know, the HIN or the entity, you know, facilitating exchange, anybody who's sending you information has to have the ability to send and exchange that information amongst themselves. And if they're not enabled to do that, then you're not going to probably meet the definition. But we're going to be working more on how, you know, once we get all those questions in, so keep them coming, to give further guidance on this definition. Thanks, Beth.
Thank you, Mike. Mark, I'm going to ping you. We have several questions again. They are different variations on a theme, so I'm trying to sort of group things together so we can get to as many as possible. The EHI definition itself, I know we just discussed, and I reiterated to make sure we were all being clear, that when we talk about the US CDI in the information blocking timeline, we're really talking about a list of the type of data rather than those very specific standards that are identified in the US CDI and certified technology. But let's come up one level. Can you talk a little bit more about the EHI definition itself? Like, what do we mean by electronic health information when we're talking about information blocking provisions?
Sure. Yeah, and I know we've got a lot of questions, and I've seen a lot of questions about this as well. And it's kind of a similar answer to what Mike just said with the HI and HIE definition, is that we're not really in a position to weigh in on the different specific types of data, whether they are or not considered electronic health information. I guess just to level set, like you said, for the first 24 months, for all intents and purposes, that EHI would be the data elements represented in the US CDI. And then after that 24 months period, it would kick over to the full EHI definition. And then you would need to look at that definition to determine whether the specific data that you're interested in would be considered electronic health information. And again, that EHI definition is electronic protected health information that's in a designated record set, regardless of whether the group of records are used or maintained by or for a covered entity. And it doesn't include psychotherapy notes or information compiled in reasonable anticipation of or for use in a civil, criminal, or administrative action or proceeding. So if the information or data in question is covered by this definition after the 24 months, it is covered by the information blocking provision. And then for the first 24 months, like I said, it's a more limited scope of electronic health information. That's just the data elements represented in the US CDI standard that was adopted in section 170.213. I hope that helps.
Yes, thank you. I'm going to skip ahead a little bit. I'm actually going to interject and do my own answering of a question because I see several that fall squarely into my bucket. There are several people who are asking about the interaction between the ONC rule and the CMS rule. And several folks who are asking questions that are probably more related to some of the CMS rule requirements. So just to identify for everyone, the CMS final rule for interoperability has several policies that relate to the various Centers for Medicare and Medicaid plans, like CHIP and Medicare Advantage. So those different plans are now required under CMS's final rule to exchange certain types of data through an API. And those provisions are separate from the information blocking provisions. There is alignment across both what CMS is requiring and what ONC is talking about in terms of saying things like the US CDI, so that we're all talking about the same data. Again, in information blocking, it's not specific to those standards, it is specific to the types of data that have to move. So the CMS rule for clinical data does reference that. It also, both rules align to HIPAA and HIPAA definitions for things, but that is separate. So the requirements for payers to share specific data with patients via an API, several questions have asked about that. Those are under the CMS interoperability rules, and we can follow up with our CMS colleagues and let them know that you're asking those questions so they can be sure to get out to their networks the answers to those questions as well. So I just wanted to take that little side trip there because I've gotten several questions on that. Mike, I have a question for you. There are some privacy and security questions. There's several actually. I'm going to try and summarize, but I think maybe going through with a little bit more detail about the privacy exception and the security exception, probably specifically the privacy. It looks like most of these are sort of thinking about how that relates to HIPAA and what oversight there is for privacy and security within the information blocking provision. So can you talk a little bit more about that?
Well, Beth, I'm going to actually ask you for a little more information. Are you talking
Sure.
about like secondary use, or are we talking about whether or not there's consent or authorization on behalf of the patient to get access to the information? I guess I need to get a better sense because as always, it is you know, case by case, fact specific. So
Well,
Are we just gonna?
there's several.
Right.
So let me ask a couple specific things that have come up.
Okay, sure.
The first off, privacy and security rules trump the information blocking rule. That has come up. So the relationship to other existing law might be a good thing to cover.
Sure, I can do
The
that.
next thing to cover would be what about educating patients? What can a provider do or not do with relation to third parties and the risk of third party applications? That's coming up.
Great.
Let's
tackle those first
okay,
too.
go for those
How about
first.
that?
Yeah.
'Cause, all right. So I think you said that your question of whether or not what trumps what, right? We talked about this in the proposed rule, and I talked about it even earlier today in this presentation. If the law says not to send what would be EHI, then you wouldn't meet the definition of information blocking. So we talked about in the final rule, court order, administrative decision by, like, for example, FTC, EEOC, state law, another federal law. But we also talked about HIPAA a lot, obviously, the privacy and security rules in the proposed rule and in the final rule. And in many instances, it's permissive. Really, conditions have to be met before information can be shared under HIPAA, but there's not necessarily a preclusion from sharing that information, and outside of certain circumstances. So, like a business associate agreement, we can talk a little bit about that one if we had questions about that, Beth. But generally speaking, like the way to get the benefit of under information blocking of the privacy exception, you have to have in place policies about how you're going to meet the required conditions. So, for example, a good one is if consent is required, and which is a lot of times the case before information is shared. So what we've said in the rule is that if in the instances where consent is needed and somebody attempts to provide the appropriate or even authorization, the appropriate authorization form or consent form, and there's something wrong with it, that alone isn't a reason to reject the request, that you need to take reasonable efforts to help that essentially be perfected. So providing the appropriate form if they're not using the right form, or identifying what information is missing that needs to be filled out, so that, because clearly in that instance, there's been an actual attempt to convey and meet the condition, convey the consent or authorization and meet the condition. So to get the benefit of the privacy exception in that instance and not be considered an information blocker by not providing the information, that would be a step that would need to be taken. So that's example there. When it comes to business associate agreement, we've got a lot of questions about that in terms of, am I required to share if my business associate agreement says that I shouldn't? And I think the best answer is twofold here. Normally, no, we're not asking anyone to violate the business associate agreement, but it also depends, right? Because let me try to show you an example of a more fact-based situation. What if the business associate agreement said that it's permissive to provide right of access to patients? It's not part of the required use of the business associate agreement, but that can be made available. So there it isn't. You're not violating your business associate agreement if you were to give the information. But then the question becomes, would you be an information blocker if you didn't? And I think it depends on, are other exceptions that apply? Does a security exception apply in that instance? Is it infeasible for whoever you are as a business associate to do so, and you're an actor under information blocking provision? So what generally I'm saying is, is the content and manner exception apply? Are there other exceptions that may apply in that instance where you're not going to where it could be an interference? You're not just going to be able to rely on the business associate agreement. Another great example that we've given in the rule is if you are doing something on behalf of a covered entity related to treatment, but in a particular area, you aren't sharing that information with a certain provider system. And the provider from there has, one of the patients, and they're asking for the information, and you're not sharing all of the EHI. Then the question is, why is that? So we're going to look at the agreement. It just because, because maybe in the agreement, either sides, which could be even the business associate, who may be a covered, or maybe an actor, a health IT developer, has exercised their market power with the provider that they signed the agreement with to have them agree to not share with that other health system that identified, because they're using a competing EHR system, for example. Or maybe it's the actual covered entity who is also a provider and actor under the program, who doesn't want to share across town because that's a rival as well. And so for competitive reasons, they don't want to. So that's why I said, no, we're not asking you to violate the business associate agreement, but it doesn't mean that from an information blocking perspective, we can't look at the business associate agreement and see if there were pretexts and how it was designed to essentially block the sharing of information. So hopefully that answers a couple of those nuanced privacy situations. Oh, and then I think you asked about educating, right? So we have a lengthy and hopefully a very helpful discussion in the final rule about educating patients about sharing their information and how that would not be considered an interference under information blocking, and that we actually encourage those actions to be taken by actors. So there are various ways to do that. I won't spend too much time here because I know I want to try to get us in some other questions, but it can go to whether or not they have these other entities that a patient wants to share information with, whether or not they have a privacy policy, what's in that privacy policy, including will they sell their information, will they share their information with other entities without express consent from the patient. And these are all things that you can, as an actor, make your patient aware of before they choose to share that information with, whether it be an app or another third party, say personal health record of some sort. So I encourage you to take a look at that, and we'll obviously be able to open to answer some follow-up questions. So Beth, back to you.
Sure. So we are almost at time. So I am going to ask one more question, although I realize this is a can of worms question just from how many of the questions in the queue this relates to. Can you talk a little bit more about fees? And is there a list of specific fees or cost categories that are allowed or will not be considered information blocking, or how reasonableness is determined? There's so many variations on this question. It might be good to just sort of talk about the basis for the fees and excluded fees, if you can cover that in 2 minutes.
Hey, Mark, you want to start out on that, and maybe?
Yeah, sure. Yeah, definitely. You need a little break. Happy to talk about it. I'll do it quickly. So I mean, as far as questions that relate to whether questions about specific fees or cost categories that would or would not be considered, information blocking or an interference, the way we looked at it was that any fees could be potentially considered an interference, but we need to look at the reasonableness of those fees to assess whether, it would be information blocking. And we created this exception where we created a framework where we look at the basis for the fees. So things like whether the fee is objective and verifiable, whether it's reasonably related to the actor's costs of providing the type of access, exchange, or use of EHI, whether you're treating competition differently with regard to fees than others. And we also, in the exception, flag excluded fees, that these are types of fees that would not qualify for the exception. So things like a fee based in any part on the electronic access by an individual, their personal representative, or another person or entity designated by the individual to access their EHI, or a fee to perform an export of EHI via the capability of Health IT certified under 173.15b10. So I guess that's a long way of saying that we've created this framework for determining whether fees are reasonable. And we do, again, allow for profits under the fees exception. But I guess, as Mike said, we're looking into clarifying perhaps the reasonableness questions. But all I can say right now is what we have in the rule and the framework that we laid out concerning fees. Oh, and actually one other point, though, that I do want to make, Beth, is that with regard to APIs in the condition of certification, there are more explicit fees laid out there. And so I encourage folks who are developers that are covered under the program to pay close attention to the permitted fees section within the API condition of certification.
Yeah, and I know we're over, but I want to just hit quickly on another part of it, which is patients, right? We talked about a patient having no cost access, so no fees for electronic access to their EHI, right? And we essentially said, like, any charging of a fee would be inherently suspect on, under information blocking. But I think there's a couple key components I want to highlight here about this. So it's electronic access we're talking about. It's the individual, it's EHI, right? And it can be the electronic access by their personal representative, another person, or an entity designated by the individual. So that entity can, as we talked about in the rule, I think it's around, I don't know, page somewhere in the 900s, maybe like 960s-ish, about an app or its developer. They could be an entity that was been designated by them, and so they could not be charged a fee. But what key points to lay out here is it has to be electronic access, and we define electronic access as an internet-based method that makes EHI available at the time the EHI is requested and where no manual effort is required to fulfill the request. And we go on to say, in terms of fulfilling a request without manual effort, we clarify that it entails the completion of the process where there is no manual effort involved to meet the request at the time of the request. And we say, to illustrate the inverse, we recognize that there are times that manual effort may be involved in collating or assembling EHI from various systems in response to a request. And so in such instances, you wouldn't be under the definition of electronic access, and then it would fall into what are reasonable costs and profits that can be charged in that instance of providing the EHI. So I wanted to hit on that individual, more nuanced use case, which is where patient access. Okay. Thanks for that extra minute.
I appreciate it. Thank you, Mike. So we are actually 5 minutes over, so we will let everyone go. I did want you to know that your questions are not going into a black hole. We will be reading through all of them and using them to help guide some of the things that Mike mentioned earlier, whether it's frequently asked questions, the information that we're trying to get from the public about the HIN and HIE definitions so that we can inform the long-term approach for guidance and answering questions and providing advisory opinions as that continues to evolve. So thank you very much for joining us. Again, this webinar recording and the slide deck will be available on our website as soon as they are made 508 compliant. And we hope you will join us for the next in our series. For those of you who had questions related to the technology specifically and the conditions of certification, join us in 2 weeks. We will be having the experts from the technology team specifically addressing those exact types of questions, and I'll save these to make sure that they answer them on that webinar on the 22nd. So thank you so much. Have a nice day.